to record. And without further ado, we're going to begin. Welcome everyone to our seminar dealing with South Sudan's war crimes courts and the prospects of international criminal justice and in dealing with the terrible crimes that committed in that, in one of the newest countries in the world. We are delighted and really grateful to have a really outstanding panel, and we really thank the panelists for joining us both from South Sudan and from the United States, and thank you very much. I'm Professor David Bilchitz, the director of the South African Institute for Advanced Constitutional Public Human Rights and International Law. I welcome you all. I'm going to shortly hand over to Rebecca Ratner, who's a researcher based at SciFac, who's going to chair this seminar. Just to let you know in advance, if you want to join our mailing list, please mail, I'll put it in the chat, naomi@scifac.org.za. We have a fantastic lineup coming up next week. We have a launch of Professor Stu Woolman's new book on Wednesday called Wrecking Ball, and dealing with how we address wicked problems, and that will be at 5:30 South Africa time on Wednesday. And then we start with a 10-part climate change series, a multidisciplinary series on climate change, starting on the 15th of April. And that will also be at 5:30 to 6:30, 1-hour seminar. So we've got many things coming up, a further book launch later on. And so please join our mailing list to know more about our activities. This is part of our Africa series. So we're placing the spotlight on various countries, and now on South Sudan. We hope to do, obviously there's been some terrible events happening in the Tigray region of Ethiopia and and we will want to spotlight various aspects throughout the year. So please look out for our Africa series. Without further ado, I'm handing over to Rebecca.
Thanks very much, David. Hello and welcome everyone to this seminar today on the hybrid court and accountability for war crimes in South Sudan, hosted by SciFac and the Konrad Adenauer Stiftung. We're very happy to have you all join us and our excellent panelists for this important and timely discussion. Only 2 years after becoming the world's newest nation, South Sudan became mired in civil war in 2013. The conflict began when long simmering tensions between President Salva Kiir and Vice President Riek Machar erupted with fighting in Juba between factions loyal to the two leaders. The ensuing civil war resulted in the deaths of tens of thousands, with one study estimating the death toll to be as high as 400,000 and the displacement of more than 1 million people. A UN report, amongst others, has documented egregious and widespread war crimes perpetrated by both the government and opposition parties, such as the deliberate and brutally violent targeting of civilians and sexual violence, including the gang rape of children. Numerous attempts to negotiate lasting peace have failed, though there has been some progress with the 2018 peace deal and establishment of a transitional government headed by Kiir, with Machar as his first vice president. Progress remains slow, and violence continues in many parts of the country. Accountability mechanisms for war crimes are one of the many slow-moving components of the 2018 peace agreement. But now, after years of inaction, there appears to be some prospect for progress on the establishment of a war crimes court for South Sudan, with the government recently announcing its approval. The concept of a hybrid court to be organized in partnership with the African Union was first articulated in the 2015 Agreement on the Resolution of the Conflict in the Republic of South Sudan. Unlike previous criminal tribunals across Africa, organized under the auspices of the UN with significant influence from Western countries, the hybrid court is intended to bring together South Sudanese and African expertise to hold perpetrators of war crimes accountable. Despite recommitting to the 2015 peace deal in September 2018, South Sudan's leaders have repeatedly sought to block establishment of the court. And although the government recently authorized the Minister of Justice and Constitutional Affairs to begin the process of establishing the hybrid court, there are significant questions about the process and structure that need to be answered. We have an excellent panel presenting today to discuss the intersectional issues of peace and justice in South Sudan. Our discussion will start with 12-minute presentations by each of our speakers, followed by a 25-minute Q&A session, and then a short conclusion.
Yeah.
During the Q&A, people are invited to post questions about the presentations through Zoom and for their names if they would like to speak verbally. Unless called upon to speak, we ask that everyone turn their video off and remain on mute, please. So as not to take up too much time, I will just very briefly introduce each of the panelists before they speak with a short summary of their backgrounds. We'll get started with Mr. Dang's presentation, followed by Dr. Ensor, then Dr. Lariche, and concluding with Dr. Lunger. David Dang is a human rights lawyer who's been conducting research and advocacy in South Sudan since 2008. Mr. Dang currently serves as an advisor to the Transitional Justice Working Group, a platform of 8 civil society organizations that has been working to promote transitional justice in South Sudan since 2015. I'll let Mr. Dang take it from here. Thank you all very much for joining us.
Thanks so much, Rebecca, and thanks for inviting me to be part of this meeting and for convening it on such an important and timely issue. I should say from the outset that I'll be speaking from my perspective as an advocate and the work I've been doing in South Sudan over the years. That being said, I do recognize the complexity of this issue and that people do have contrary viewpoints and welcome the opportunity to engage with those different viewpoints. So I hope this discussion can really be open and can honestly engage with where people are coming from. The reason I have sort of adopted the position and settled where I have with respect to justice in the hybrid court is really driven by the possibility of breaking the cycles of violence in South Sudan, which date back to before Sudan's independence in 1956. And in my opinion, part of the reason why South Sudan remains as unstable as it is because you have this very difficult context in which to operate, hugely complex issues. I think there's this tendency to fall back on established way of doing things just because they seem to be the easiest and safest options in the short term. However, over the longer term, the danger of this approach is that it kind of fosters a race to the bottom in which people lose the kind of ambition that's needed to tackle the really difficult problems that South Sudan is facing. So with respect to justice, the way that this has manifested is a reluctance to address some of the terrible things that South Sudanese have done to one another in these successive civil wars. The typical approach in the context of peace processes has been to offer amnesty, political and financial rewards to individuals who wreak havoc across the country in order to encourage them to come back into the fold. This serves to legitimize the violence against civilians as a means of obtaining power or retaining power. And then meanwhile, the people who are on the receiving end of this don't see any prospect for justice. They end up taking matters into their own hands, and we have a whole new generation of radicalized people who become caught up in new conflicts. So for the first time with this current conflict, which South Sudan has been grappling with for more than 7 years now, we've seen people beginning to question this approach in a much more serious way than they have in the past. And sort of more resistance to this idea of approaching peace solely on the basis of political accommodation. So I think with that by way of introduction, I thought I'd just speak to 3 sets of issues briefly. First, some of the questions around peace versus justice, which I think is typically invoked to say that now isn't the right time for us to be thinking about accountability for international crimes in South Sudan. We should wait until the situation is more stable, and why I think that maybe is not the right approach. Secondly, to this issue of political will and how we understand it, and some developments I've seen in recent years that give me some reason to hope or to see prospects that we could muster more political will than people sometimes assume. And then lastly, just some thoughts about a more practical strategy about how we could approach the hybrid court and transitional justice more broadly, looking at the short-term options. So on the first question of peace versus justice, one of the reasons why I think this reasoning misses the mark is that it's premised on this idea of something called war and this idea of something called peace, and that as we move from one state to another, all these opportunities will magically open up. And in my opinion, this isn't really the right way to think about these transitions in the South Sudanese context. It's not this linear. There's a lot more continuity between periods of war and periods of peace than we sometimes appreciate. We can look back, for example, to the interim period that followed the signing of the CPA. Shortly after the CPA, there was a disarmament exercise among the Eastern Nuer in Jonglei and Upper Nile, which was hugely abusive. There's a statistic sometimes quoted that 3,000 weapons were seized in this disarmament exercise, and 1,500 people were killed. So one person killed for every 2 weapons that were seized. Sadly, we're seeing the same thing today. Despite the peace agreement being signed in 2018, of course, the transitional government formed in February of last year. We're seeing intercommunal conflict rising in sort of to unprecedented rates, or to rates that haven't been seen in a long time, and much of it is linked to national politics. So these things, I think, represent the kind of continuities between war and conflict, and the perfect time to hold people accountable for atrocities is never going to present itself. So I think the better way to approach it is to ask, how can an institution like the hybrid court function in a very insecure, unpredictable environment, and how can we design it to address the specific drivers of conflict in the South Sudanese context? Moving on to the question of political will, I think on this question, sometimes we make a lot of assumptions about what political leaders will and won't do, and we undervalue the progress that's been made thus far. The way that the question is often asked is, how can you expect these people to prosecute themselves? And I think in trying to think about that question, I look back to the commission of inquiry that was established by the AU shortly after the outbreak of the conflict. It documented, it did investigations throughout the first, say, 6 months or so of the conflict, and completed its report in October 2014. This report was shared with the parties in early 2015, and they wholeheartedly endorsed it. I vividly remember at the time the Minister of Foreign Affairs, after being given a draft of the document, saying that they fully agreed with it. And then they proceeded thereafter to sign an agreement with an entire chapter devoted to transitional justice in 2015. And then again in 2018, they've worked with the AU to develop a statute and an MOU that would spell out the kind of structure of the court. And most recently, there was an announcement by the government that they would be moving ahead with the establishment of the Chapter 5 mechanisms, and the Ministry of Justice was tasked to be the focal point for that. So I understand there are serious problems of implementation, and political will remain, and I don't cite these examples as evidence that it's going to be clear sailing from here on out. But the fact that they have gotten this far, I think, is not something that can be fully dismissed. In addition, I also draw some encouragement from developments at the national level, especially over the last 1 or 2 years. It started with the Terrain trial back in 2018, where there were convictions of about a dozen soldiers for abuses that were committed during the July 2016 violence. People often portray this as the government placating international partners because there were expats among those who were abused at Terrain. But actually, some of the research that's been done shows that there were government actors who were playing key roles in moving this process along before it even got to the headlines internationally, and before that international pressure manifested itself. So people like Mariel Chanwang, the late James Ajongo, some of these military figures who really pushed this process ahead. There are others who resisted it, but there was action from the part of South Sudanese that I think sometimes isn't fully appreciated. And on top of that, more recently, over the last year, there have been a series of military court-martials, first in Ye towards the middle of 2020, and then in Bentiu towards the end of 2020, in which the government for the first time has begun prosecuting some lower-level soldiers for crimes committed during the conflict. And again, this was done in the context of COVID. I don't think international partners were really aware of what was happening, particularly in Ye. So it wasn't the result of international pressure, but it was something that was generated due to politics inside South Sudan. So anyway, I thought those were examples that could kind of help, concretize this question of political will a bit more. And then lastly, sort of looking ahead and thinking about what can be done. One of the things that we've been advocating for is a more phased approach to the hybrid court. So to begin, for example, by establishing some kind of investigative capacity within the AU as a precursor to the full establishment of the court, so that the AU can begin compiling evidence and building cases and can start the work. We've seen now the AU Commission of Inquiry, as I mentioned, the UN has a Commission of Human Rights on South Sudan that has been operating in the country for many years. So they show that it's possible to do these investigations even during, active conflict. And this would sort of help to get the process started. And then, looking ahead, once the body is established, it will take, some time for it to become fully operational. And then from there, most prosecutorial strategies would begin by going after lower level people who are, not so senior, less politically sensitive cases, and over time work their way up to the more politically sensitive cases. So, even if a hybrid court were established today, it might be 5 years or more before we see, some of the more people who hold the most responsibility held accountable, or cases brought against the people who hold the most responsibility. So when you take into account the fact that this kind of sequencing is built into just the nature of the institution itself, I think it also favors an approach that starts sooner rather than later in terms of trying to make progress. And then I think a second priority, in addition to this idea of a kind of phased approach, would be to think about how we can increase South Sudanese ownership over the hybrid court, but also transitional justice more broadly. And that requires us taking this elite pact, which was negotiated among a few dozen people in a foreign country, and thinking about how we can foster a sense of ownership among the people. And if we fail to do that, I think there's a big risk that it could be seen as a foreign initiative that South Sudanese really don't have any vested interests in. And I think to do that, it requires, of course, public outreach, and we need to, I think, be much more robust in how we approach this as civil society and others, but also thinking through the legacy question in a bit more detail, and how do we design the court so that it really results in, helps to build South Sudan's capacity to address these sorts of conflict-related crimes itself. I think I'll stop there. Maybe I'll just end on the point that we're talking about the hybrid court, obviously, but it needs to be situated within a more holistic approach. And I think there's a tendency to really focus on criminal accountability, in part because it's has an easy narrative about sort of impunity and holding people accountable. There's clearly measurable indicators, and there's a big international industry behind it, but there's a danger that it kind of sucks the air out of the room, and that we neglect some of the other things that need to be done to address, the legacies of violence in South Sudan. And I think that includes other mechanisms provided for in Chapter 5, but also thinking outside the context of the agreement and thinking about the institutions in South Sudan and how do we bring those into the process, thinking of traditional authorities and other institutions within the context. Great, my power has just gone off, so I think I'll take that as a cue that I should stop speaking. Thanks.
Thanks very much, David. That was great and really informative and insightful. I'd like to now introduce Dr. Marissa Enser. Dr. Enser is a gender and youth specialist with a background in the human dimensions of conflict. She's been conducting fieldwork in South Sudan for over 15 years and is currently an adjunct professor at Georgetown University's Justice and Peace Studies program. Oh,
Am I unmuted? All right.
Now you are. Great, thank you.
All right, well, good morning, good afternoon, good evening, everyone, depending on where you are in the world. Thank you, Rebecca, for that introduction. David, tough act to follow. As Rebecca has noted, I am trained both in social science, sociology, psychology, anthropology. My PhD is in applied anthropology, and in law, specifically in international and human rights law. And I often alternate between wearing my social scientist hat or my human rights lawyer hat. And one of the reasons why I'm fascinated by transitional justice approaches, which include both judicial and non-judicial mechanisms, is that I get to wear both my science and law hats at the same time. So I'm very grateful to have been invited to participate in this event, and thrilled to be in conversation with my fellow panelists and with all of you in the audience. And I would like to begin by remarks by quoting a fellow anthropologist, Claude Lévi-Strauss, who famously said, "A good scholar is not someone who already knows all the answers. It's someone who knows what the right questions are that need to be asked." Well, in that vein, I do not presume to know everything that needs to be done to help South Sudan transition to a state of justice, peace, and reconciliation. Instead, what I would like to do today is share some reflections on the issues that require attention if we are to ensure that no one is left behind, especially women who are at risk of being sacrificed in the process. Now, I think it's hard to overstate how critically, how important accountability is to repairing the country's social fabric and to the healing of victims or survivors. But how is this accountability to be accomplished? Failure to adhere to the timelines of the 2018 agreement, which was a protracted political stalemate, delayed the formation of the new government and the completion of key appointments, putting the establishment of the transitional justice mechanisms on hold. These delays have meant that the underlying causes and drivers of the conflict have continued to fuel localized violence, rampant corruption, economic and sexual crimes in South Sudan. Meanwhile, those responsible for war crimes and continuing human rights violations have been emboldened by a system that permits impunity for torture, enforced disappearance, and atrocity crimes against women and men. The absence of accountability and reparation, including for sexual violence, undermines the fabric of society, breeds resentment, and defers the prospects of reconciliation and healing. The victims also continue to bear multiple burdens of physical, psychological, and socioeconomic consequences of the violations. The delay in establishing the promised transitional justice mechanisms has robbed the women and men of South Sudan of the opportunity to achieve sustainable, positive peace. And I probably don't need to remind this audience of the difference between negative peace and positive peace. So just very briefly, negative peace is merely the absence of reduction of overt violence, while positive peace creates the conditions that eliminate the causes of violence, including direct and structural violence. It emphasizes the promotion of human rights, reduces social inequalities, and promotes social justice. The situation in South Sudan has historically been characterized by a succession of long periods of overt violence, separated by interwar periods of negative peace. Positive peace is yet to be achieved. My research reveals widespread differences in interpretation of the causes of the conflict. The majority point to the struggle over SPLM leadership, followed as a tie by ethnic competition and a clash between members of the army. There is also considerable dissatisfaction with the timing and manner in which the national dialogue was conducted. The establishment of the dialogue process occurred via presidential decree while South Sudan was still in conflict. Many South Sudanese express a concern that it may have been designed as a cover to shield some political actors from accountability for conflict-related violations. Many of those citizens who engaged with the process were openly critical. Many South Sudanese stakeholders, especially the opposition, rejected the findings published by the National Dialogue Steering Committee. These failed to generate wide consensus, or at least acceptance of different interpretations of what happened about the core facts and circumstances of the conflict. So it follows that until there is greater understanding about some core facts and about what transpired and why, there will be a little common ground to proceed with national reconciliation efforts, as many have noted. For instance, during a consultative conference with religious leaders held in Juba in November 2019, a number of faith-based organizations on the one hand pledged support for the national dialogue process, but on the other hand, they still called for the immediate establishment of the Commission for Truth, Reconciliation, and Healing. A truth-seeking effort could contribute to the development of a shared national narrative of the conflict. By itself, however, it is unlikely to be enough to lead to reconciliation because, among other things, it fails to provide accountability. Some other commentators have argued that in a fragile and deeply polarized country such as South Sudan, it would be difficult to achieve accountability by adopting an adversarial approach to justice. They instead propose that traditional approaches to justice, including admissions of guilt, as well as compensation in some circumstances, may be more suitable. However, this approach is also unlikely to prove satisfactory in the cases of sexual and gender-based violence against women and girls, and to a lesser extent, also men and boys. This type of violence intensified during the open conflict, but it is extremely common even during interwar periods. The scale and severity of sexual and gender-based violence has remained significantly high after the signing of the revitalized peace agreement. These include multiple incidents of rapes and gang rapes, sexual slavery, abductions, forced marriage and pregnancy, mutilation of sexual organs, as well as killings at the hands of both government and opposition forces. Even various government officials, including the Minister of Defense and Veteran Affairs and the Chief of the South Sudan People's Defense Forces, have publicly acknowledged that members of the government of the government security forces have been involved in perpetrating sexual violence. Yet, victims of SGBV continue to face significant challenges in seeking justice. Across the country, victims and survivors continue to express reluctance to report their experience because of stigma, rejection by their families and communities, fear of reprisals, and lack of confidence in judicial and non-judicial responses. Most cases of this type of violence continue to be heard by traditional customary courts, which are not equipped to meet international fair trial and due process standards. These courts are often conducted in open public spaces with mostly male community members in attendance and are presided over by male elders. Women who speak out in front of their community about their experiences of SGBV are often subject to stigmatization and further physical abuse. Furthermore, rape and sexual violence are seen not as individual crimes involving only the perpetrator and the survivor, but as collective issues affecting the entire community. The type and level of justice accessible to survivors is influenced by factors such as the victim's age and marital status, social standing, and perceived value, often in relation to bride price. What's more, the justice that is available generally takes the form of reparations, often to the woman's family, not herself, as determined by customary elders, rather than individual legal redress for the survivor. We should also note that men are also reluctant to speak out about the sexual violence they have experienced, as they often perceive it as a process of emasculation and as a loss of their social role, leading them to face equally strong societal stigmatization. From a legal point of view, South Sudan's penal code criminalizes acts of sexual violence, including rape, abduction aimed at facilitating non-consensual sexual acts, and genital mutilation. The definition of those crimes, however, does not conform to international standards. The definition of rape, for instance, does not include marital rape and is limited to intercourse, excluding other forms of sexual violence. Furthermore, crimes against humanity and war crimes are not criminalized as such in South Sudanese law, meaning that sexual violence cannot be prosecuted in South Sudan under those crimes. It follows that prosecution of acts of sexual violence under South Sudanese domestic law fails to reflect the scope and the gravity of the violations that are being committed during and after the conflict. As a result, perpetrators of these heinous crimes are emboldened by the belief that there will be no serious consequences. Crimes go unreported because survivors have no faith that anything will be done, or worse, that they will be attacked again for speaking out. Now, the revitalized peace agreement expressly precludes the possibility of immunity or amnesty for criminal responsibility. Non-immunity has long been established as a fundamental principle in international criminal law. My own research reveals that the majority of South Sudanese reject impunity and resented the de facto immunities that were inherent in the 2005 CPA, Comprehensive Peace Agreement. This is part of what the hybrid court is intended to correct. The hybrid court will have, according to the agreement, jurisdiction over the crimes of genocide, war crimes, crimes against humanity, and I'm quoting, other serious crimes under international law and relevant laws of the Republic of South Sudan, including gender-based crimes and sexual violence. It will have the mandate, and I quote again, to investigate and prosecute individuals bearing the responsibility for violations of international law and or applicable South Sudanese law committed from the 15th of December 2013 through the end of the transitional period. Now, this is important. The court is to consider crimes committed not until the signing of the peace agreement, but until the end of the transitional period. Now, the transitional government of national unity wasn't established until February 22nd of 2020, as David already noted. That is what marked the beginning of a 36-month transitional period ahead of the holding of elections in accordance to the revitalized peace agreement. So if I'm interpreting the letter of the agreement correctly, the crimes that are committed until then are still subject to the jurisdiction of the court. Another point of law, Resolution 1820, adopted by the UN Security Council in 2008, noted that rape and other forms of sexual violence can constitute war crimes, crimes against humanity, or a constitutive act with respect to genocide. I think this is legally significant. War crimes can only be committed during an armed conflict, but crimes against humanity can be committed both in times of war and of peace, even if it's negative peace. All that is required is that crimes against humanity must be committed as part of a widespread or systematic attack upon a civilian population. So the campaigns of sexual and gender-based violence committed in a calculated manner to terrorize and punish individuals and communities in South Sudan, even after the peace agreement was signed, meet that criterion. Okay. The prohibition of crimes against humanity is a peremptory norm of international law, meaning that no derogation is permitted and which is applicable to all states. From the perspective of most survivors, healing and reconciliation without enforcing justice and accountability will be meaningless and tantamount to an acceptance of impunity. Many communities in South Sudan have undergone numerous healing and reconciliation events, and the same communities have engaged in acts of revenge and violence after a short period. Will legal accountability, as is expected from the hybrid court, serve as a deterrent for future violence? Maybe, maybe not. It will depend on how it is done. We must admit that there is a clear risk of overselling it, raise expectations that will not be met, and that's fuel grievances that might further destabilize the country. In spite of that risk, what is clear is that South Sudanese women remain marginalized in political institutions and governance, as well as in transitional justice discourses. They are being denied any meaningful form of justice, and this must be corrected. As the expression goes, nothing changes if nothing changes. We must avoid what has been known as elite bargains, by which women's rights are sacrificed in the name of national peace and security or reconciliation. Okay? A case in point that comes to mind is the current situation in Afghanistan, where the international community is pushing forward a power-sharing deal between the Taliban and the Afghan government, couched as a peace agreement, which is already resulting in Afghan women paying the price. And here I note the similarities with the situation in South Sudan with respect to a power-sharing agreement couched as a peace agreement. Now, I'm always flabbergasted by arguments that the rights and well-being of women and girls could be sacrificed in the name of the higher interest of the community, as if females were some kind of add-on and didn't constitute part and parcel of every community. In fact, women often represent a larger demographic proportion than men because we have a longer life expectancy. So any suggestion that women's rights be sacrificed in the name of the interest of the community is a euphemism for women's rights are sacrificed to prioritize the interest of men. This is morally unacceptable and legally untenable. The women and girls of South Sudan deserve better. So I'll end on that note because I'm running out of time, and I thank you.
Thank you very much, Dr. Unser. That was really insightful and fascinating. And you made some really interesting points about women and girls' rights and sacrifices and compromises that have been made in previous contexts. Next, I would like to introduce Dr. Matthew LaRiche. Dr. LaRiche is an assistant professor at Ohio University, where he also serves as the director of the Global Leadership Center and War and Peace Program. He's been working on issues relating to South Sudan since 2004 with a focus on the nature of conflict and politics.
Thanks. Sorry, thanks very much. So I guess, you know, I'm the more I'm the less legal of the panel. So and a bit of background on how I've gotten into the discussion with respect to the hybrid court. My interest has been focused on the way, the conduct and nature of war going back to previous iterations of conflict before the recent civil conflict from 2013 onward. And one of those areas of interest that became an important focus for me has been how international norms and international actors have influenced the way domestic actors have conducted violence, and conducted violence is a part of seen and understood as a part of a broader process. So to sort of frame this, and listening to the other panelists already who've presented some very important and key elements, my sort of real essential point here is that getting this right is of essential importance. Many people in South Sudan that I interact with, there's a clear problem, which is everyone expects to find justice in this mechanism, or no one gets it. And that's where this is sort of distilling out, when, as you probably quite rightly understood from Dr. Deng and discussions and comments, that in practice that's really not likely, that there has to be something that's fundamentally going to be much more pragmatic. I like to think of this court as an opportunity to do something different, and I agree that up to now most international engagement and most engagement on these sorts of issues have been continuing to replicate the same kinds of structures and mechanisms that we've seen for a very long time. And the South Sudan case really shows that these mechanisms, have not been able to change or break the cycle of violence, to use the conversation about this. So this court is an opportunity, like in some other cases of post-war conflict, to sort of define the new state. So the way I frame and think about South Sudan currently is, South Sudan is not a failing state. South Sudan is just at the cusp, the beginning of its post-colonial moment. It's the beginning of its liberation moment, and as a result, what we're witnessing and observing is very much, tragically following the same patterns of state emergence and state creation that most states have gone through, that we've seen around the world. So trying to find another way to do this is essential. And this is an important juncture, I feel, an important opportunity to try and find a way to do that. So to go from the high sort of strategic thinking about how the court, presents an opportunity to do that, and to sort of, come down to the particular, which is, how that sort of happens, and how do we get it right? Contextualized, making sure it's contextualized so that it's legitimate to parties. Frequently, depending on what aspect of the court you talk about or justice you talk about to different communities, very much it becomes, justice for our group, our community, but not the other community. And so that's a very difficult balance to strike. And so making sure that this court is legitimate, strikes at the heart of that. And that's, connected to political support and political will. But it's also, about being able to convince the broad-based communities that, about how they understand the conflict and what took place. I wouldn't go as far as to say that we need to define specifically, the facts that took place. My own research has shown that, depending on where you stand, the facts look very different. And this links also to the fact that a big part of the cycle of violence is very much driven by the fact that the further violence are justified by previous acts of violence, and very much of the war is oftentimes framed as a way to find justice. In the absence of a functioning or effective state, right? We know very well that that war is used as a way to frame and mete out justice. So if this is not done right, there is a very high risk that we will continue to see the same dynamics play out, and as South Sudan slowly evolves as a state. It is far from fitting the clear definitions of a sort of a coherent nation state, as much as many that sort of in the way that many in the international community would understand that. So within that framework, getting it right, I think will come down to some key concepts, some key elements. I'll sort of pick out the idea of command responsibility as very important. And command responsibility really sort of often hits at the hinge of any of the criminal aspects of a war crimes tribunals, going back quite some time. So, and in the South Sudan case, we do have a lot of antecedents, or we have a lot of material to go with to build this. It's not a sort of clean slate the way that sometimes commentators might think. Everything from the SPLA code of conduct, going back to the SPLA in previous conflicts, of which many of the factions and leaders of the factions that were belligerents in the recent conflict, were leaders of at that point in time. So acceding to norms associated with command responsibility and how that might work and be understood. But getting it right is really key in that command. What comes with implementing, a court that with certain elements of command responsibility understandings is also about getting right our understanding of command authority in the context of this conflict and this war. And so, what that means is there's going to have to be a lot of precision about making sure that it's not just that one holds a rank. It's that within the framework of how an individual has authority over the conduct of violence is paired up and matched up well with how someone prosecutes crimes associated with command responsibility. I'd like to sort of extend this into sort of a discussion also of the important aspect of, as the court is stood up, is this going to be this debate over the extent to which what took place, as a whole was just or unjust? And certainly most of the parties to the conflict, feel that they're and have set up their justifications for engaging in the conflict as perceiving this as a conflict. And that links to this tension that we have, that both my colleagues there have pointed out, that we have this tension between the issues of justice for the individual and the perceptions of justice and security of the community. And very much communities within South Sudan, and still do in many respects, often see these conflicts and the politics surrounding them as zero-sum situations. And they will quite rapidly move to defend or protect the community, or the anticipated, the fear that the community may be undermined or even worse. And so trying to manage that very complicated path is going to be very significant in how the court is framed, and how it's everything from the communication surrounding it to the actual sort of prosecutions when someone gets to being able to bring that about. We've got a whole litany of details. So Dr. Ding talked about sort of design and how this is sort of going to be designed, and the purpose of this. And it again goes back to the sort of broader idea that this court, has the potential to be a moment of disjuncture. So, this court could be definitive in what the future South Sudanese state could look like. So it's very much more than a court to prosecute specific war crimes, although they will figure significantly in that outcome, because of course we have communities that are going to be watching this very acutely, and everybody is going to be demanding some level of justice from what takes place, and will be very suspicious of the authorities associated with the court. So managing this is again, going to be very difficult. Again, getting it right is going to be very important. And there's a number of other sort of principles that that the court's going to have to sort of contextualize and frame and communicate effectively, both to satisfy the local communities, but also I think a very difficult part of this court is going to be that there are very much international elements to this, and it is very much coming at the behest and pressure from many players in the international community. And a real test of this court is going to be the extent to which it can actually reach out and include accountability and responsibility for regional and international players that have been a part of what has taken place. And there certainly is an awful lot of that as well. South Sudan has emerged within a certain global environment and a certain international environment. And that's going to be very important for us in how we understand and think about this, and how the court then can be legitimate, credible, and effective. And up to now, there really hasn't been enough debate and deliberation on how those elements are going to be satisfied, how the court's going to be able to do that. Dr. Den quite rightly pointed out that we've got lots of other cases, right? This is certainly not starting from scratch. And South Sudan also has a very long tradition of judicial courts and, going back long before the colonial period. So there's a lot to pull on. There's a lot to integrate. The oftentimes perception of a disjunction between the traditional or customary apparatus and some of what we're talking about when it comes to international humanitarian law and human rights law, in my mind, is not as big a disjuncture as sometimes we think. It's sometimes down to the language that's used to communicate these ideas and principles. So there certainly is a deep sense and desire and understanding of accountability and reciprocity. Sometimes it takes forms that oftentimes don't look the same as what some people particularly in Western states might observe, but there certainly is a depth of doctrine and principles to draw on, and certainly a long tradition of legal and juridical figures and leaders who have been debating and discussing these issues, and so there's a very rich tradition to draw on to sort of bolster and support what exists today. So that long tradition going through the early norms that were written into first the SPLA, then into the government, later in the SPLA Act itself, and are there to be drawn on. And many of the figures, quite interestingly, which is I think also very significant, many of the figures who have been central in writing and framing some of these principles in the SPLM, SPLA, and the Constitution, current versions of the Constitution that have evolved over the years, are still players in the political space and are a part of this power sharing arrangement and are a part of this context. So inculcating them and bringing them into this, making sure they are sort of what they've worked on in the past, right? The norms that they have espoused in the past, and formalized in the past, are going to be, key to this, and having them front and center also makes this will be very important. As a result, I think in one respect, I agree that there's a lot to work with here. I think the problem is, one of the things about making the court work is the extent to which it's properly supported. Political will is one thing, and there's been some political will that Dr. Deng pointed out. But beyond that, the practicalities of actually building these mechanisms outside of really of the military courts that the South Sudanese military has had, that have been really undermined over the previous few years. But other than those institutions, there's very little to draw on in terms of, you think the practicalities of showing up at an office, of showing up at a, day to day to get these things done. And so, of course, anyone who's spent any time in the environment knows very well how challenging that is. And so, so just being able to find support to do that. So there's a very important role for the international community to play on that. And I would sort of reference, if we spend most of our time looking at the role of the International Criminal Court and, international justice mechanisms associated with, courts on criminal courts and finding prosecutions. But an important part of those institutions was also, meant to be able to support these kinds of initiatives and trying to find the ways to support these things practically, whether it be through personnel, whether it be through resourcing and whatnot. So I think, there's quite a wide range of issues that we really need to hash out. But I think, one of the things that, so they'll sort of leave with the sort of final, my final point is really that this court it has the potential to be a definitive moment in the emergence, in the state building process of South Sudan. This is not, simply a moment of finding accountability for specific narrow crimes committed in a case of violence. It's much more, I would say, sort of monumental in will be in the sort of the history of the sort of emergence of South Sudan as a state, and sadly is not very united, and so the court has to work hand in hand with some kind of a national dialogue, which, as the previous presenters pointed out, has already been fraught with serious politics, and been brought under real question in itself. It's been used as a justification to assert, and use violence and threat in the fear that a process like the national dialogue or the peace process was going to sort of draw boundaries or exclude certain people and include others, and so violence was used to sort of preempt that. So I'll leave you with the thought that how monumental this moment is and the potential it presents with doing something a little bit different, and the risks associated with just doing the same. And so I'll pass back to Rebecca, and I think we've got our final panelists. Thank you very much.
Thanks very much, Matthew. That was fantastic. To conclude our presentations, I would like to introduce Dr. Santino Ariwa-Longar. Dr. Longar is an assistant professor at the University of Juba's School of Law. He holds a PhD from Queen's University and is a member of the Canadian Bar. His research focuses on international human rights, constitutionalism, and the law of armed conflict, as well as land laws in South Sudan. So Dr. Longar, you're up now.
Thank you, Rebecca. Thanks to the Institute for organizing this important discussion. Thanks to my fellow panelists, and I would like to divide my presentation parts. First, transitional justice, the third, justice, and the fourth part will deal with the key role of transitional justice in post-conflict societies. And the final part will be the application. Of course, I know that, there is an issue of time, and if I find myself running out of time, the last part would be my focus. It's the most important part. No, transitional justice generally seeks to it's often a remedial, or rather a quasi-judicial response to violation of human rights. Justice for the victims, as well as promotes the idea of practice of sustainable peace, state and nation building. Now, transitional justice itself is not a special form of justice on its own. Rather, it is a form of justice adopted and customized to accommodate specific needs of especially post-conflict societies that are transitioning toward abuse and decades of war. Hello?
I think it's a little bit choppy on the audio. Perhaps you could try turning off your video and seeing if that improves the connectivity so we can have clear audio.
Okay. All right.
Thank you.
All right. So is it better now?
Yes.
Hello?
Yeah, we can hear you now.
Okay.
Thank you.
So, okay, thank you, Rebecca. So the objectives of transition addressing the issues of abuses, especially by a dictatorial government or parties that have committed this kind of crimes, and some would say without endangering the interests of peace or political transformation of society. And that is why normally some would refer to transitional justice in the context of post-conflict societies as a multidisciplinary quasi-judicial process, because it involves investigation of alleged violation, and in this sense, it also involves truth commissions, commission that investigate and reports and make recommendations as to the appropriate remedial action with the view to instituting an effective deterrence. It also involves reparation programs, in the sense that it's aimed at repairing material and moral damages of systematic abuses. This may be symbolic to victims, in the sense that they may take the form of financial compensation or, official apologies. Transitional justice involves, transformation of the security apparatus. It aims at transforming security forces such as the military, the police, the national security forces, and judiciary, as well as other law enforcement institutions, from repressive practices into institutions of public service and integrity. It involves gender justice, because in any conflict, women and children tend to bear the brunt of war and human rights abuses. So transitional justice program must challenge the culture of impunity and predatory sexual abuses, as well as gender-based violence, with the view to emancipating women and girls. Transitional justice involves building, memorial symbols and archives. They always say that those who forget the painful part of their historical mistakes are bound to repeat them, And I have been in Rwanda, and I know how impactful it is to have structures that serve to commemorate the Rwandan genocide. So building such structures in South Sudan, as well as in any broken society like ours, does not only preserve, painful memories of society as a whole and of victims in particular, it also serves to raise moral consciousness about past systemic abuses, such consciousness operates as a bulwark against occurrence of such crimes. And then the complexity of the issues of transitional justice. Many issues, arising from war abuses and war-related hazards are often too complex to be solved using a single model of justice, such as courts. This is especially the case when there are thousands of victims and perpetrators. For instance, first, without programs such as reparation, truth and reconciliation targeting, when you target a small number of individuals, this may be seen as a political witch hunt. So the aspect of reparation may serve to mitigate the perception that it is not political witch hunt. Second, truth and reconciliation alone, without punishing those most responsible for the egregious abuses, may shield, serial violators of human rights. And just as reparation without linkage with prosecution may be seen as amounting to purchasing the silence of the victims. So transitional justice as a key to peace and transition to democracy. A transitional justice program should be designed with a view to promoting democratic governance and sustainable peace, especially after periods of mass political violence and human rights abuses. These objectives should be participatory in nature, in the sense that they should be reached with a wider consultation and participation of victims, the general public, government, civil society organizations, and especially women. It must address the underlying causes of war, since the state is the primary violator of human rights abuses in mass political violence. It must undertake, reasonable steps to protect and promote human rights, investigate allegations of human rights, and impose serious sanctions on those directly responsible. As much as it can afford, the state must ensure that the victims of human rights abuses are compensated, and it must promote the rule of law. That is when the concept of transitional justice may be effective. So how appropriate is the so-called what we call hybrid court in South Sudan? Application of transitional justice to South Sudan is more likely to face a number of factors. First of all, the model of transitional justice itself. Is the hybrid court the most appropriate model? It is adversarial in nature, in the sense that it's, hybrid court built on a Western model tends to lead to an outcome that may be seen as a win-lose one. A win-lose outcome is not may face issues in South Sudan. And second, since it is a model, a Western model, can it really work in South Sudan? There is a precedent that what normally works in South Sudan is what is domestically generated. For example, the 1999 Wounded Peace Accord among Western and Nuer Dinka was effective because it was domestically initiated. The 2002 agreement between the SPLM, led by John Garang, and Riek Machar and Lemakov, and the 2006 Juba Declaration between Kiir and former warlord Matip-Nial were effective simply because they were initiated domestically. So a hybrid court may also be problematic because it may be seen as inconsistent with the African concept of restorative justice. Restorative justice is a collaborative approach to justice where the victims and the alleged perpetrator or offender and the community meet face to face to share their experience of what happened, determine what was was harmed by the impugned conduct. The offending party has to admit wrongdoing, apology and forgiveness are given, and consensus is forged as to the way forward in terms of repairing the damage or making amends, and if necessary, and making sure that deterrent mechanisms are instituted. This is usually followed by reconciliation. In this sense, the traditional system of justice is often based on reconciliation, rehabilitation, taking full responsibility, redemption, and it provides relief to the victims in terms of, because adversarial justice tends to, the loser tend to see themselves as powerless, and those who win in courts tend to feel that the world is just around them. And this kind of solution to injustice, to abuses, do not work very well in this kind of environment. The third one, the final one, is what Matthew had just talked about, determining command responsibility. Can the right person be actually prosecuted in South Sudan? The rubric of international law that has developed in recent decades has established that commanders and other superiors are criminally responsible for war crimes committed by their subordinates if they knew or had reason to know that the subordinates were about to commit or were actually committing such crimes and did not take all necessary and reasonable measures in their power to prevent their commission, or if such crimes had been committed, to punish the person responsible. Now, applying this concept in South Sudan will be difficult for a number of reasons. For example, will the right people be prosecuted? Where does the chain of command begin? Are we talking of commanders in chief, the chiefs of both sides in war, or are we talking of ground commanders? Second, in mass violent conflicts, most key players to the conflict have their constituencies. The most important article was written by President Thabo Mbeki and Professor Mamdani in 2002, talking about the fact that in mass political violence, key players tend to have constituencies. And so prosecuting particular individuals would be seen by those constituencies as a prosecution of their own constituency as a whole. In South Sudan, those constituencies are ethnic groups. And so the challenge of making sure that the right people are prosecuted will be severe in South Sudan. And so a model that blends both the importance of justice and peace is preferable. So hybrid court justice system is not enough for implementing transitional justice in South Sudan. And that is because adversarial form of justice in South Sudan cannot be effective in the face of the present state of fragility in South Sudan. If you do not have a functioning machinery, the hybrid court system is going to face a lot of difficulties. Furthermore, in light of the fact that South Sudan is an ethnically polarized country, the most appropriate vehicle in South Sudan may actually, the vehicle of transitional justice may be a blend of truth, healing, and reconciliation. So only a mechanism that is cognizant of the imperatives of promoting peace and justice can find moral purchase in South Sudan. So restorative justice involving, truth, reconciliation, and healing, and a blend of traditional form of justice could work better than hybrid court if we have to build a South Sudan that that is more viable. Thank you so much.
Thank you so much, Dr. Lunger. So moving on now to the Q&A session, we've gotten a number of really great questions. I'll start by posing 3 different questions. Some are specifically directed and some are for all of the panelists. And then we can go around. So the first question we have is, Dr. Deng spoke about the importance of fostering South Sudanese ownership. What are some of the ways that this can be done, specifically in the design of the court? And in this respect, what can be learned from previous tribunals? And the second question is, my worry with the court is the fact that both sides still have power and the conflict is not really resolved. What incentives are there for the political actors on both sides to make the war crimes court work? Isn't it ultimately in their interest that it fails? And finally, we have a question. Would it be possible for Dr. Lariche to discuss more about South Sudan's legal history and how this can be drawn on and the advantages of doing so? So I think we'll start with the question for Dr. Dang, if that's okay, about the South Sudanese ownership.
Yeah, thanks. Sorry, my power keeps coming and going. I'll speak to that question. I also wanted to speak to the question of interest. I think part of the difficulty that we have now is that everything that's in the long term or most of the things that are in the long-term interest of the country are not in the short-term interest of the leadership. And it's not just transitional justice, it's, reforms across the board. So, among the priorities now is the creation of a unified, necessary unified force, which would be like a unified military that's supposed to represent the diversity of the country. But part of this means that the leaders would have to disband the militia that are protecting them in these, these armed groups that give them their, very basic protection as, VIPs in Juba. And I think the prospect of them disbanding these militias and creating an independent military that would sort of be a threat to their own personal safety, to them, that's probably more of a threat than the prospect that some court will eventually be established and bring cases against them and find them guilty. And that involves a whole long chain of things, whereas the the need to create a professionalized military, I think strikes at a much more, something that's much more close to them. Or if you look at economic reforms, it's not in their interest to have greater transparency, but so long as all the wealth of the country is being siphoned off, without any restrictions, then South Sudan is not going to be stable. So I sort of see transitional justice in a similar way that, yes, in some ways it's not against, it's against the interests of people who are responsible for atrocities, but, in order to address the conflict and to resolve what is accumulation of generations of, entrenched behaviors that lead us into conflict time and again, we have to find ways of doing things that are difficult. With respect to outreach and how to sort of foster South Sudanese ownership, I think there are practical things. So starting early is something that other hybrid tribunals haven't done a great job of. Also engaging government and trying to, make the case to them for why this is in the interest of South Sudan, the South Sudanese people, and even for, their various institutions, particularly thinking about the judiciary and other justice sector institutions. I think, were the AU to do some kind of capacity assessment of South Sudanese legal professionals, they've had now many years to start thinking about that and trying to identify judges who could potentially serve, South Sudanese judges who could potentially serve on a court. I think all of that sort of thing helps to increase ownership. And then there are a number of other transitional processes that are called for under the peace agreement, including the constitutional development process, which I think provides space where we can begin engaging South Sudanese around some of these questions, and even, retrofitting some of these transitional justice institutions to address the concerns that people put up. I have a slightly different take on the national dialogue, I think, than what some people have put forward. I think the way the presentation of the kind of ulterior motives is I think, applies and is something important, in the lack of inclusivity. But at the same time, once that space was provided for South Sudanese, they really stepped up and engaged in a very frank way with the national dialogue. And it resulted in a lot of very critical feedback about the government and a lot of calls for justice. If one goes back to look at the reports on the National Dialogue website, you'll see consistently this issue of impunity coming up as a problem from the grassroots that they want to address, including through criminal accountability, among other sorts of justice. So I think, as that national dialogue process, of course, it's finished its consultations, it engaged 20,000 South Sudanese across the country over the few years of its existence. And now as it moves to sort of implementation phase, I think there may be opportunities there also to, if it actually is implemented, to use that to kind of raise awareness around some of these ideas that we've been discussing with transitional justice.
Thanks very much. Moving on to the next question, which was about the court and whether both sides still have the power and the conflict is not really resolved, and what incentives there are for political actors on both sides to make the court work. And this is for all of the panelists. So I suppose we could just maybe start with Dr. Enser and then Dr. Lariche and then Dr. Langer, and then circle back to Dr. Dang, give him a couple minutes break.
All right, so is the question, what are the incentives for those who committed the crimes to participate in their own trial? Well, it seems like a strange way to phrase the question. I don't know whether, and I think one of the presenters already mentioned this, that there are short-term interest and long-term interest, and that perhaps it isn't in the short-term interest of those who are currently in power to go through a process in which they themselves could be prosecuted. But I don't know that the difficulty of the process should preclude the attempt. And considering that other alternatives that have been attempted have failed, and that
we maybe have a connectivity issue. Perhaps we could just move on to Dr. Lariche now on this question, if that's okay.
Yeah, sure. So, on incentives and disincentives, and this is something I thought a good bit about and engaged on in a number of contexts. There are some incentives for being willing to allow oneself to be a part of this process. There are a lot of senior figures in South Sudan who see their actions and their role in the broad arc of history. So some of them are thinking about their place, in the long-term memory of the emergence of South Sudan as a country, or the liberation, so to speak, of their people. So there are a number of individuals who I think would be, if the conditions were right, would be interested to make their case that the actions that they took within the context of what they may frame as some version of supreme or some extreme emergency, that they were either defending the victory, which was the liberation of Southern Sudanese from Sudan, from the sort of and the history of oppression that occurred, and that they would want to make that case. So there are some incentives. Granted, I suspect there are very many also who would not feel the same way and would actively work to avoid being subject to this kind of prosecution. So there are also a lot of disincentives. Dr. Deng pointed out, a big part of this is also, hingent on or contingent on the nature of the security sector. As long as individuals have their own armed forces, and let's be very honest about this, individuals in South Sudan have their own armed groups, right? And have continued to possess their own armed groups, have always had their own armed groups. Mobilization has always been about convincing particular leaders to bring to bear their networks of loyal supporters and followers. So this is a big problem, and the incentives will be less as long as those structures remain very entrenched. Now, that's not going to be a very easy thing to do, as I've written about this in other places. There is really very little example of military integration or the integration post-conflict of armed groups as being effective. In fact, I would argue that in the South Sudan context, the effort to integrate armed groups has been a key trigger of and return to warfare. So we've got a very major problem of design connected to the security sector reform process that's been undertaken and continues to be undertaken using ideas that have been borrowed from elsewhere. So that's a big problem when it comes to sort of incentives or disincentives. But I do think that there are reasons. There are very many people who see their role in the recent conflict and as justified, and would like to see their their memory sort of vindicated. Also, this is not so much incentive, but also connected to the idea of sort of possessing one's own sort of power base. You may be willing to subject yourself to something like an international tribunal when in fact there's very little material or immediate consequence to you as a person should you be found guilty, given the fact that you can hold power and safety and security within your own community. So okay, I'll subject myself to this international tribunal, but if they find me guilty, good luck if they want to do anything about it. And this very much has been the case. Lots of senior and sort of powerful South Sudanese leaders have made comments to this effect in a number of sort of efforts to sort of hold account, and they are able to, if you're not interested in traveling around the world and moving your bank account from here to there, there's very little that can be done. So because of that weakness, there is also the possibility that there may be able to be some movement on people being willing to allow a court to move forward because they don't feel the fear or they're not particularly dissuaded from the idea that someone might come after them. They really don't feel threatened by an international mechanism or a hybrid mechanism led by the EU or even led by Juba. So that's, in terms of the incentives and disincentives. One thing I will sort of comment on is that the military courts have been in the past one place where you could resolve certain you could go after certain individuals, and there is a sort of a history there, and that sort of links into this conversation as well in particular. But that's been challenged with respect to these militias, and so who is a combatant and who isn't a combatant? Who can be brought into this and who isn't? And many people have sort of framed it as anyone with a gun, but of course, there are so many people who would fit that definition. It's going to be very complicated. But the military courts have really been, the only institution able to do that. So finding a way to resurrect that as a part of this sort of security sector transformation process is going to be very complicated. But I can see the interconnections between the two.
Thanks very much, Dr. Lariche. That was great. We have actually more questions than we have time for, which is, I think, always a good sign. So just to wrap up now, I'd like to pose a question for Dr. Longer, and then perhaps each panelist can go around and provide any closing comments or thoughts they have very briefly, or responses to anything that's been raised in the chat. There's been a really interesting discussion going on, and Dr. Dang has provided some great examples in response to a question posed. So to conclude, we have a question for Dr. Longer on how can one blend the retributive and restorative justice, retributive and restorative, to ensure that victims also receive quote unquote justice, that their need for justice is not postponed.
That is the challenge right there. because traditionally, the South Sudanese court systems, depending from which community you come from, have different ways of applying justice. And for some, you know, in the West, there is the idea of, you know, putting people behind closed door, behind bars for years. In South Sudan, such a thing does not exist. In South Sudan, if a person has been found guilty of murder, they pay some blood compensation, and reconciliation follows. This system, this justice system, has worked for centuries. And what happens in the context of South Sudan is that when you are a person accused of perpetrating this kind of war crimes, and you find yourself, you know, in that kind of situation, and when you may actually feel guilty or not guilty, you tend to build, you know, the base of support from your own community. And so if you come, you know, if the system of justice that will be implemented during this transitional period is one based on Western model of justice, I find that difficult. And so blending restorative justice and truth and reconciliation is what I told earlier on, a quasi-judicial system. And it has to be in a form of consultation. It has to hello? Hello?
Yes, we can hear you. Maybe not. Dr. Longer? Okay, unfortunately, I think perhaps we have lost connectivity with Dr. Longer. So, but we are very close to the end of our allotted time anyways. So perhaps we can just go around, as I said, and each panelist can say some closing remarks and address any issues or comments, questions that were raised in the chat or anything said by other panelists to wrap up.
Hello?
Oh, Dr. Longer? Okay, yeah. So maybe we'll go around in the order we started with, starting with Dr. Dang, if that's fine with you.
Thanks. I thought there's a good question here about the risk that you know, prosecutions, however well-intentioned, could be viewed as an effort to target one side or another. And I think Dr. Lariche spoke to this in his comments too, and I think it's a really, really tricky issue. I would have said closer to the start of the conflict, my assessment was more that people were driven by animosity towards the leadership of the other side, as opposed to wanting the leadership of their side, you know, as opposed to supporting the leadership of their side. Kind of the way it was, at least what my read at the beginning was that if we sort of reduce it to kind of the ethnic dimensions of the conflict, that many of the Nuer were fighting about the massacre that happened in Juba towards the start of the war and blaming some of the leadership on the government side for that. And that was their driving motivation, as opposed to wanting to see, you know, the leader of the opposition, you know, back in government. And then similarly on the other side, it was driven more by fear of the other side than it was by support for their leadership. And I think in that type of scenario, one could see that, you know, if, you know, senior people from either side were indicted, it may not be as much of a threat to the people, you know, as so long as it was done in a balanced way and they saw that they were getting justice for what was done to them, that it could, you know, one could foresee a situation in which those interests kind of aligned in favor of something moving forward. Today, the situation, I think, is much more murky. just because, the ethnic dimensions of the conflict have become so much more pronounced and entrenched, and I think it's a lot harder to think about how to proceed in that, to tackle that issue. A lot of it will come down to, prosecutorial strategy, if the court is ever established, and, is this a court that's trying 3 people or a dozen people or 100 people? All of those kinds of questions will have big implications for, for how it's perceived. But I think it's right to point that out as a big risk. And I think often the most considered pushback that I hear from South Sudan is on that issue. And then maybe just one point in relation to what Dr. Santino was saying. While it's true, I think many South Sudanese do resonate with that kind of reparative justice approach, and it has a long history in South Sudan. I've also found that there's a lot of retributive attitudes in South Sudan that are a product of successive conflicts. So when you ask people what should be done to perpetrators, as often as not, they'll say they should be subject to firing squad, as that they should, pay cows or what have you. So I think while I understand that, customary justice is structured around that reparative instinct historically, I think attitudes have shifted quite a bit, and there is actually quite a lot of retributive sentiment that I hear now from South Sudanese. The challenge is that whatever kind of justice is delivered, it's going to be inadequate to address the scale of what's happened in South Sudan. So we're never going to be able to do things, at a level of what's required. So I think it really requires clarity about the objectives that are being served and managing expectations about what this one court would be able to accomplish, even if it were done in a kind of complementary way with initiatives in South Sudan. Thanks.
Thanks very much, Dr. Dang. We also seem to have had some ongoing connectivity issues with Dr. Unser, so we'll move on now to Dr. Lariche, closing comments.
Hey, thank you. You'd think by now, through all the COVID-19 stuff, I'd have figured out how to click my mute on and off. I think what's clear from everybody involved here is that the particular is confounds the conceptual, right? I mean, this is going to be a very difficult process, and no one, I don't think anyone, who's engaged in this is deluded into thinking that this is straightforward and not complicated. But I think some of the key tensions that you've heard, just now, are really going to underlie whether this is designed right or not. It is going to be, we're going to have to somehow find a balance between, restorative and retributive sort of ideas of justice. I mean, both, Dr. Santino and Dr. Deng are right. And in my own experience, I've heard both of those opinions presented to me by the same people. So people are demanding retribution in some cases, and they're also demanding restorative justice as well. So how do we square that circle? And this may not be the only, right? So as Dr. Santino said, this can't be the only element of our focus in terms of transitional justice. So it's just got to be one element of that. And I think figuring out, this issue of, and I think, looking at the recent conflict, the recent conflict isn't just the recent conflict. This is settling longer scores. This is resolving bigger issues about how the state should look, who should be in power, what that power should look like. So when we engage in sort of dealing with one community versus another, or having individual and certainly individuals who are focused on in any of these mechanisms will have their supporters and will have their communities of people behind them, and it really does run the risk of figuring out, of inflaming the sort of underlying issues that are there. We saw that with the creation of different states, right, through the ARCs period, right, where the government established a number of more states, so it could effectively delve out more positions and give communities a perceived control over their space. So so figuring out that balance, right? And there's a real resistance also to anything that ethnicizes this conflict any further. I mean, you don't need to look any further than next door in Ethiopia now, looking at how that's transpiring, right? There's a lot of examples of that. So there are a lot of risks associated with this court. But I think a point that Dr. Deng made sort of in the chat just now, and thinking about what might take place. One of the real the things that I think in the end that is going to bring this court is going to bring this court about is in a place where for so many years the international players, international community has forced itself on what's been happening in the region and on the communities and people, whether it be from other regional states or more widely. Leaders in South Sudan are very worried that what gets built, that the state building process is taken out of their hands, and they should be guiding that process. And so, insofar as that's a risk to them, Dr. Deng mentioned that they may be concerned about an ICC tribunal or otherwise, and they're going to be engaging with people in Sudan, in northern Sudan as well. This is part of that conversation that's taking place in northern Sudan as well. So there are echoes and connections of what's going on more broadly as well. So I think in the end, that's why you will see leaders agree to be a part of building this institution. Why you've seen them recently agree to it. So that's my sort of concluding remarks. But I think we need more forums like this. We need more support for efforts that Dr. Centino, Dr. Deng, others who are in South Sudan working on trying to, have these conversations that are very difficult, and they're in an environment that's very difficult, and more support for that is essential. If nothing else. Thanks.
Thanks very much. And we'll conclude with some final comments from Dr. Longer.
Thank you once again, Rebecca. I'm sorry, I think I lost you earlier on. My connection wasn't working. So, South Sudan, what happened in 2013 was just the continuation of what happened earlier on. There have been wounds of this conflict that festering, they keep on festering and don't go away. And what needs to happen is actually some form of justice and accountability. Because if you don't do that, because the same people who have perpetuated this kind of violence for over 30 years are the same players, finding themselves in the midst of this conflict. So some form of justice, some form of accountability ought to be done, to be undertaken. But the point I was talking about earlier on, blending traditional justice and modern court system is that a finding of guilt or declaration of guilt in public by the court of law is important, because it's important to the victims. It is also important to the public, identifying individuals responsible for egregious crime. It is important. But in the sentencing process, this is where traditional justice system needs to come in. If you put them behind bars, his or her community might be forced to take some action that may not be peaceful. And so if you punish them, say, because they have been found to have been involved in this kind of crime, punish them in the traditional way, say 30 cows, 100 cows, the community might find itself contributing to those cows, and the perpetrators might find that lighter. And so, and then we also need an effective state machinery, because basically the incentives to go to war has been because violence is rewarding in South Sudan. And because of that, people who go to this kind of who choose this kind of power, of way of seeking power, are not punished. They will always do it again and again. And so what needs to happen is for some form of legislative process also to be factored in to ensure that those who have been found guilty and have been sentenced in certain way are not allowed to hold public office again. So there is incentives and disincentives in this kind of, there are disincentives and incentives in this kind of court system if we blend both. But if we go that adversarial way, it's more likely to be less effective or rather counterproductive. So I think this kind of discussion is important, and we need to have it more often. But the voices of South Sudanese and the constitution of the court system itself to be able to prosecute those need to ensure that the people of South Sudan are consulted and are participants, as I think Dr. Deng said earlier on, and as well as did Dr. Matthew, that the owning this process is important as its effectiveness, and if otherwise it's seen as an imposed model, is likely to backfire and may not be effective. And so we'll be talking about this issue time and time again. So thank you.
Thanks very much, Dr. Longer, and thank you to everyone for joining us. This was really interesting and productive conversation addressing a significant issue that, as many of the panelists mentioned, will have long-term impacts. We hope you'll join us again for more of our SIFAC seminar series. And I don't know if David wanted to say anything else before we end this seminar, as it's already run a little bit over our planned time.
Thank you, everyone. Thank you, Rebecca, for chairing, and thank you to our 4 excellent speakers. We really appreciate that. I think it was mentioned by Matthew Larisha that we do want to provide support, and we want to help these processes along. And, this is a small way of doing so, but the recording will be available. The goal is to create awareness, understanding of the various challenges, and international support for it. So please, everyone who attended, you're welcome to utilize the recording. It is already on our Facebook site. We'll make it available on YouTube, and you're welcome to encourage more people to listen to it. As you see, like, people don't know much about South Sudan in some ways, certainly in South Africa. We also don't see people as a result having that much interest as well, sadly. And I think it's our duty to provide more understanding of what is going on, and also the prospects for successful criminal justice, which, as we've heard, are really complex. And I think we've unpacked that today. Also, and the need, which I know we've had discussions in South Africa about, and in other transitional justice contexts, about also connecting with kind of local modalities of justice and balancing, as was said, retributive and restorative justice. So with that, I'll just say thank you to our panelists, and we look forward to seeing you at a future seminar next week. Remember, the 31st of March, and dealing with problems of collective action, wicked problems in addressing things like the coronavirus, Professor Stu Woolman's new book, from 5:30 to 7. We look forward to having you at our book launch. Thank you, everyone, and goodbye.
Thank you.